everyone, and welcome to this new video of the Latent Export News Opportunity series. Our goal here is still the same, giving new or soon-to-be exporters elements to build or strengthen their international development strategy. Today's video focuses on intellectual property, or IP, as IP is considered one of the most important intangible assets of any company. It is important that a proper strategy be implemented to protect it, both on a domestic and international level, because there are several reasons you have to have in mind to invest in IP protection. One, to prevent anyone from copying you. Two, to bring value to your business if you intend to sell it. Three, to sell or license a third party. Four, to keep it in your arsenal if you suspect you will be sued and expect to countersue. Because intellectual property rights, or IPR, such as patents and trademark, are enforceable only in the territory where they are granted. For example, a patent issued by the Canadian Intellectual Property Office has no value outside of Canada. If anyone is seeking to protect its IPR abroad, it is necessary to file a proper application in each country. The patent will give the company the right to prohibit anyone from making, using, and marketing its invention in that precise country. As a patent can give the holder exclusivity in a market, holding a patent can provide a significant advantage by giving control over a project and limiting or preventing the emergence of competition. If not properly addressed, the advantage can be quickly lost, because competitors can lay claim to your product before you do. A recent and illustrative example is the one involving an individual called Hitesh Swani, because this man from Delhi has filed for the PS5 trademark in India back in 2019, while Sony had filed for the trademark in February 2020. So the dispute has now been resolved, but the launch of the PS5 was delayed and the economic fallout for Sony was constant. One of the first objectives you have to have in mind while thinking about international development is, as we said, the implementation of an IP strategy that goes hand in hand with your international business. This strategy has to make your company profitable in the long run. For most Canadian companies, the United States is the #1 market, and it's the place where the IP region is much the same as in Canada. In Canada and in the United States, inventors have a 12-month grace period to patent their invention after disclosing it to the public. When in places such as China, you can use a first-to-file registration process. The first person to file a trademark application will generally have priority over prior users of the trademark. And applications may also be filed and registered without evidence of use of the applied for trademark. There's other regions and other systems as well, such as Europe, which has the European patent law covering a range of legislations, including national patent laws, international convention, and a number of European directives and regulations. You have to have in mind everything before starting to protect your inventions. And because of the complexity or the need for quick resolution, it is highly recommended to contact experts in this field from the beginning of your project. Mistakes can cost you a considerable amount of time and money and might be the source of litigation between different parties involved. If your trademark has already been registered by others in another jurisdiction or another country, you may lose the rights, the control, and sometimes the entire market, as your competitors can legally manufacture and sell your products before you do. As you may know, intellectual property is defined as a product of the mind. It is ideas, it is stories, it is invention, and other intangible products. And intellectual property law is defined as the legal method of identifying the authors and owners of IP elements. Those are two different elements that works together as a system. It is a puzzle to be built. Since property law is a system, it is necessary to learn about the characteristics of each patent field. Does it give you monopoly? Is it an assignment of rights? What is the duration of the protection, etc., etc. And you have to think about all the strategies that can be used and that have to be implemented, because there are different ways to protect your IPR. The most common one can be can be explained using the following example of a shoe going through the process of protection through IPR. First you would need a patent to file. First, you will need to file patents to protect the technology needed to produce the shoe. Then, the industrial design protects the ornamental and aesthetic aspects of the shoe, such as its shape, patterns, lines of colors. After that, you have to think about the copyright, which is required to protect all the work of authorship, such as writings or music created for the shoe marketing campaign. And finally, to protect names, phrases, or logos, trademark laws are to be applied. So you see, this is an entire system, not just only one or two IPR method. And please note as well, and it's very important, that copyright is automatically established when a work is created. Canada and more than 170 other countries have signed the Berne Convention, which deals with the protection of works and the rights of their authors. There is no international copyright registration system or any kind of requirement for formal registration, but a voluntary registration of creative process can make it easier to prove ownership if a dispute arises. Most countries have a system in place to allow for a formal copyright registration. And as we were talking about the many ways to protect your IPR, you have to be aware that there are different methods to apply for IPR abroad. We're giving you only two very simple methods, but of course there are more. The first method would be to apply directly with the IP office of the targeted country when you are seeking for IP protection, because an IP professional can assist you in navigating the local system of the targeted country. Second method would be to use an international application system, which can save both time and money when applying for IP rights in multiple countries. Again, you will be in contact with an IP professional who will provide guidance and an estimate of potential cost saving. That can be interesting if you have to apply multiple. And finally, it's always a good idea to have available an updated log of evidence that documents the evolution of intellectual property rights. For example, dated and signed copies of drawings and drafts. Of course, it is highly recommended to contact a patent or trademark agent for help with searches and license to ensure that any intellectual property you create is adequately secure. And that would be the last advice for today's video. Let us know what you understand about international IPR, and let us know as well how you dealt with related strategies. Have a great month and see you next time.